Thank you for joining me. My name is Maria Madrid. I'm the Director of Latino Services at the Colorado Gerontological Society. I'm excited that you wanted to join me today to learn how to complete your living will. This is going to be a step-by-step tutorial. This meeting is being recorded and we'll make both the recording and the form available to you after this session. I will also turn off my camera so you are able to see the entire screen and to help you to follow us along as we go. Feel free to ask me any questions in the Q&A or chat. At this point in time, I will turn off my camera and let's get started. So my objectives for you today is to learn how to complete the living will. I want you to know what information is needed, what are the best practices to follow, and once you've completed your form, who to give copies to and how to store it. So let's begin with a quick review of what is a living will. So a living will is one of the various advance directives available for individuals here in Colorado. Your living will works in conjunction with the medical durable power of attorney. So the medical durable power of attorney is the legal document that appoints who is going to speak on your behalf. This appoints your agent. This is the person that if you become incapacitated, you're not able to communicate, this person would be able to speak on your behalf. The living will is used for you to document what medical treatment preferences you have for end of life medical treatment and care. And individuals that are 18 and over with decisional capacity are the ones that should be completing this document. So for whatever reason, if the individual no longer or doesn't have decisional capacity, they should not be completing an advance directive. They should be looking at being supported through a legal guardianship. So let me emphasize also that the information that I'm providing today is Colorado specific. Every state has their own regulations and statutes of what constitutes different advance directives. So please note that this is Colorado specific. All right, so let's jump into what information is needed. So let me begin with really emphasizing that there's no right or wrong when it comes to medical preferences. This is for you to document what medical treatment you want, what makes sense to you, and really to provide your agent with instructions for your medical treatment. Let me step back for a second because there are two schools of thought when it comes to the living will and should you complete it. So these two schools of thought focus on do we need it, and if we need it, why do we need it? So remember, the living will works in conjunction with your medical durable power of attorney. It outlines the medical treatment. The first school of thought says if you have completed your medical durable power of attorney and you've been in conversations with your agent and they know your preferences, they know what you would like in different situations, that individual is pretty knowledgeable and could advocate for you. So a living will is not necessarily needed for that school of thought. The second school of thought thinks the living will is definitely needed, especially because it'll be used in a high emergency situation, and it's used as an outline of your preferences. So that way your agent during that moment of high stress has your instructions for your medical treatment. So I recommend everyone to have a medical durable power of attorney, because that way someone could speak on your behalf. When it comes to the living will, it's basically your choices and your preferences. If you feel that this will assist your agent to support you during end of life, then this is definitely an advance directive that you should make sure to make part of your advanced care planning. So what is the information that you need before? There's some conversations that need to take place with your support system, with people that are important to you, whether it's blood family, chosen family, a religious leader, your doctor, those individuals that are part of your support system, because you're going to have to make some decisions about life-sustaining procedures. Do you want them? Do you not want them? Do you want them for a period of time? You will also have to say if you want artificial nutrition and hydration. Do you want it? Do you not want it? Do you want it for a period of time? Would you want it if recommended by a doctor? You would also need to know whether you want to be an organ and tissue donor. Is that a yes? Is that a no? If you do want to be a donor, do you only want to donate organs? Do you only want to donate tissue? Do you want to donate both? So this is why it's so important that you have those conversations before completing this form, because they're pretty important preferences. And like I said, there's no right or wrong. It's what makes sense for you. The other thing that you would need to consider also is your agent, by means of your medical durable power of attorney, they already have authorization to speak on your behalf with your doctor and medical personnel. So the other option that you can go ahead and include on here is if you want your if you want the medical team to consult with other individuals. They don't have any ability to make any medical decisions, but they're able to, the medical staff are able to speak with them. So I do have a question that came in, and I think it's important for us to clarify. Does this form replace a most or 5 wishes form? So let's begin with the 5 wishes form, because this is typically something that I do address in these type of webinars. So the 5 wishes form is a marriage of the medical durable power of attorney and living will. So you either have the medical durable power of attorney and living will as separate documents, or the 5 wishes. You should not have all 3 because you have at that point invalidated the previous document. So if you have the 5 wishes and that's the document that you want to use, it is a valid document. The only thing that I will caution you with the 5 wishes is there's a lot of room for you to give a lot of explanation. Make sure that that information is legible. Make sure that that information is clear, because what has been found is that it's very difficult to sometimes try to decipher exactly what the person meant by what they put on paper. Whereas the living will form that we're using right now, it says yes or no, and it gives you a time frame. So I would recommend using the medical durable power of attorney and the living will as separate documents. So that way you have the opportunity to be very clear and nothing's left for possible interpretation. Secondly, the most form. The most form is for chronically and seriously ill patients. This is a doctor's order that you would have to complete with your doctor. And it's exactly what it says. It's a doctor's order that indicates what kind of medical treatment you want at end of life. And this document tells other medical staff exactly what level of medical treatment you should be giving you. And if there's any confusion or further explanation, the most form refers people to the living will. So you also need to have a medical durable power of attorney if you have a most form, because the most form only says what medical treatment you want at end of life because you are seriously ill, you have a chronic illness, and you still need someone to speak on your behalf. So you would still need that medical durable power of attorney. So I have another question, and just to clarify, you either have the medical durable power of attorney or 5 wishes. You do not have both. Let's say that today I completed my medical durable power of attorney, and next week I complete the 5 wishes. By completing the 5 wishes, I have invalidated the medical durable power of attorney. Now the 5 wishes includes that piece within the document. So you do not have both. You have either one or the other. Okay, so let's go ahead and move forward with the living will. So before completing your living will, we want to make sure that you've already had those conversations with whomever your support system is, and you've made your decisions based on your preferences, based on what makes sense for you. So before completing the form, we want you to consider if you want to get this document notarized. Now, the document is valid without getting it notarized, but it's additional level of protection, especially because every state has their own rules and regulations. So we want to make sure that you are just considering getting it notarized. The other good thing about getting documents notarized is the notary is an unbiased person in the mix of things that is basically making sure that you are the person that you say you are. They're checking your ID, and they're making sure that you're signing this document without any pressure from anyone. And the other thing is this document does need 2 witnesses to be valid. So you're just taking care of 2 birds with 1 stone, getting it notarized. So if you are considering it getting notarized, just note that that is an additional step, and whether you get it notarized or not, you will still need 2 witnesses to make sure that your document is valid. Gather all the information before you start completing the form. This typically helps the process because now you're completing the form and you're not looking for information in various places. So once again, the information that you will need to be able to complete this form is if you decide for anyone to be informed that you are hospitalized and you're at end of life, you will need those individuals that you want to be informed. So you will need their full names, a phone number. You will also need to indicate relationships of that person if you're giving authorization to consult, the medical doctors to consult with those individuals. And once again, those individuals do not have decision-making abilities. They only are there to support you and be able to speak to the medical personnel, but they will not be able to make any medical decisions for you. So let me go back and reiterate that the living will works along with the medical durable power of attorney. So you need to complete a medical durable power of attorney that assigns who your agent is, who is going to speak on your behalf, And this document works in conjunction to tell your agent who is going to speak for you and what medical treatment preferences you have. And your documents, when completed correctly, you will be able to use them anywhere in the US. When you travel outside of the US, that's a different matter because now you're dealing with other countries and they have their own rules. They're a whole separate government. So know that that's why we recommend notarization as a best practice, so that way your documents are respected across the board in the US. So let's move into how to actually complete the form. In front of you, I have provided you with an image of the form in its entirety. It's a 2-page document. So we will go section by section, and so that way you know what is being asked of you. And when you're ready to complete the form, you can refer back to this webinar recording, and you could go through the process and complete your form. So before we begin with the actual, here's where you need to put your name. Depending on how you're completing the form, there's some best practices. If you're going to complete it on your computer or your laptop, then you don't have to worry about legibility because you will be able to type it in. But if you're completing it by hand, make sure that you use a pen, either black or blue ink, in that the information is legible. Why is this important? We want to make sure that your document cannot be altered, and we want to make sure that in the time of need, that whoever has the document in front of them, they're able to read the information clearly. So section 1 of the living will, this is where you are saying who you are. So with this example, we're going to use Jane Doe as our person that is completing their living will today. And they're declaring who they are. So she is Jane Doe, and she is saying she is at least 18 years old. Why 18 years old is because under the law, when we turn 18, we are considered adults. So we are no longer under the protection and guardianship of our parents. So this is why it's 18 years of age. And it's also saying I can communicate and make my own decisions. So I have that decisional capacity. So that's the first thing we have to do. Who are we? We're confirming that we're 18 years old and that we have that decisional capacity. So section 1A, this is where it starts asking you questions about what kind of medical treatment you want. And the information, as you see it right now, it's been blown up. So you're able to, or enlarged, for you to be able to see it. And note that the colors that I'm using is just to make a difference between the different options. It has no value attached to the color. Like I said, there's no right or wrong. This is what makes sense to you and what are your preferences. So the first question under a terminal condition. So if you were to have a medical, a terminal condition, and you're at end of life, do you want life-sustaining procedures? You're only able to initial one of the options, and you could say no by putting your initials. And this says, no, I do not want life-sustaining procedures, but I do want to be kept comfortable and pain-free. So even though you have said no life-sustaining procedures, you will still be provided with comfort care and free of pain. So life-sustaining procedures could be anything from CPR, intubation, medication to keep your body going. Your other option under life-sustaining procedures under a terminal condition is, yes, I do want life-sustaining procedures. You could leave it at yes, or you could also include a time frame or goal. The way that I've seen individuals use this, it could be, for a week, for 14 days, until my family from out of state arrives. So these are different options that you could use as a time frame or goal. Those should, if you do decide to get life-sustaining procedures, that should definitely be something that works for you, and you could give that time frame, whether it's 2 days, 7 days, 30 days. That's completely up to you. Just know that you will have to write that time frame in this line provided here. Okay, so you initial one, either no or yes, and if you say yes, you could give a time frame. So we're still under terminal condition. The second question is artificial nutrition and hydration. So here you have 3 different options. The first option, and once again, you only initial one. The first option says, no, I don't want artificial nutrition and hydration. The second option says, yes, I want artificial nutrition and hydration, and you could give a time frame. So you could say, 2 days, 7 days until my family from out of state arrives. Whatever that goal looks like for you, you could go ahead and write it here. The third option under artificial nutrition and hydration is if medical possible, and advisable by your doctor or other healthcare providers that are taking care of you. So you're able to say which one of those makes sense for you, which one, what preference you have in that area. Once again, no right or wrong. This is specifically what you want your care to look like. And artificial nutrition and hydration, this is a fluid that is given to you via IV. It's very important, and this is why I say have the conversations with your doctor beforehand, because our medical history, conditions, and so on could make a difference in this area in what choice we make. So this is the first area. Terminal condition, you have to say if you want life-sustaining procedures and if you want or don't want artificial nutrition and hydration. So now section 1B, this is specifically to a persistent vegetative state. This is not a coma. This is beyond a coma where we're not going to wake up from this state and be the person that we were prior to this vegetative state. So just like a terminal condition in the previous questions, we're going to answer the exact same questions. We're going to say our thoughts about life-sustaining procedures and our thoughts about artificial nutrition and hydration. Remember, you could only initial one. For life-sustaining procedures, it's the same format. No, I do not want life-sustaining procedures, but still keep me comfortable and pain-free. Or you could say, yes, I do want life-sustaining procedures, and you could go ahead and indicate that time frame or goal in the line provided. The second question under persistent vegetative state is artificial nutrition and hydration. No, we don't want it. Yes, we do want it, and give a specific time frame. Or yes, if it's medically possible and my healthcare providers are recommending it. Once again, no right or wrong. This just means you are making the decision what you want that medical care to look like at end of life. So now we're in section 2. So section 2 specifically deals with other directions. This is where you could provide other directions to your agent to follow. So for instance, if you want to be in a hospice program, if you want to remain at home, if you want to discontinue or refuse any type of treatments such as dialysis, transfusions, antibiotics, any of those things. If you decide to give these directions, you need to initial yes. I have attached other directions. So that means you're going to have to type up what those directions are and attach them to your document and make sure that you have them. If you're going to get your document notarized, that you have attached those directions during the time of notarization. If you decide not to have other directions for your agent, then you go ahead and initial the second option that says, no, I do not have any other directions. So once again, completely up to you, but I know that this section is used when individuals refuse blood transfusions because of their religious practices and beliefs. So this is an option where to document such things if that is your case, or if you have different treatments going on, such as dialysis or chemo or any of those things. So section 2 specifically focuses on that. And just remember, if you're going to select yes, you need to complete that document separately. So I recommend that you type it so it's legible and it's easy to read. You could also handwrite it, but know that if you're going to do handwriting, once again, we're going to use a pen, either black or blue ink, and we're going to make it legible so when this is used at the time of need, the person could read it, whoever has it in front of them, okay? All right, so section 3 of the living will form. So this is the resolution with medical power of attorney. So you need to initial 1, and here is where you're deciding how this document is going to be used. So the first option says, my agent, under my medical durable power of attorney, shall have the authority to override any of the directions stated here, whether I signed this declaration before or after I appointed that agent. So this means you want your living will to be used as a guidance, and your agent has the ability to change any of the medical treatment that you have outlined. So if that is what you want and want to give your agent under your medical durable power of attorney the ability to have that flexibility based on whatever the situation is, you could go ahead and initial here under this blue box. If you want your living will to be used exactly as you have completed the document, then you want to initial the second option. Okay, this is where you're saying that your directions, as stated, they cannot be overridden, they cannot be revoked by your agent under your medical durable power of attorney. So the two options here are completely up to you. It's once again, no right or wrong. It's just how you want things to look like as far as your medical treatment at end of life. Do you want this document to be used as an outline, as guidance for your agent to know what your preferences were, and based on the situation, what they should be looking at and considering? Or do you want this document to be used exactly and for that treatment to look exactly as you indicated under terminal condition, and under vegetative state. So whichever one you decide for yourself, you initial, you put your initials there, and make sure that you only initial one. So section 4, consultations, consultation with other persons. So this is where you authorize healthcare providers to be able to talk about your condition and care with the individuals that you list, but they are not able to make any decisions as far as your medical care. Only your agent under your medical durable power of attorney has that ability. So here, Jane Doe gave Georgia Doe, her daughter, that permission. So in her case, her daughter will be able to talk to the healthcare providers, discuss her condition and care. They could keep her updated, but Georgia is not able to say anything about Jane's she's not able to make any decisions about Jane's medical care, okay, because Jane has specifically only given in this area the ability for Georgia to be able to communicate with the providers and to be updated on her condition and what's the care. That's the only thing that Georgia will be able to do. So once again, make sure you include a full name, and you do have to include the relationship that you have with this person. This form has 5 different lines for you to go ahead and document. If you have more than those individuals, you could go ahead and attach that to your document. And if you change your mind at any point, then you would have to review your document and complete a new one. But this is what it would look like. And just know that if you're handwriting this, it needs to be legible, please. So section 5, notification of other persons. So this is, you want those individuals to be notified that you are hospitalized and you're end of life. It doesn't mean that they will come to the hospital. It just means that you want those individuals to be notified. You're saying who they are under the name, and you're giving a contact point, whether it's a phone number or whether it's an email. So Jane said, I want Georgia Doe to be contacted, and here is her phone number. Make sure that when you're listing a phone number, you include the entire phone number, including area code and the full phone number, okay? Secondly, if you're going to give an email, make sure it's the entire email. There's many times that I've seen that individuals will only list the first part. So for Lily Doe, it would only be Lily Doe, and they forget the hotmail.com or at yahoo.com or you know, any of those other domains. So make sure that the contact information is provided completely, so that way there's no issues about getting a hold of those individuals. Once again, this form provides 5 lines. If you have other individuals that you would like to be notified, go ahead and attach that to your document. And once again, these individuals that are going to be notified, they do not have any ability to make decisions about your medical care. These are just folks that you want to be told that you are hospitalized, and for them to come in and essentially pay their last respects. So let's move on to section 6. This is where you indicate whether you want to be or don't want to be an organ and tissue donor. Okay, you have two options. Once again, no right or wrong. This is for you to document what makes sense for you and what are your preferences. So you're able to say, yes, I do want to make a donation, and you could say which one. You could say organ and or tissues. You could say only one and not the other. So make sure that you initial if you want to be a donor, that you put your initials here, and then you check which one, if it's only organs, if it's only tissues, or if it's both. And of course, we're saying, if this is medically possible. Or you could say the other option that is no, I do not wish to donate my organs and tissue. I cannot emphasize that once again, there's no right or wrong. This is your choice. I could tell you that personally, from having conversations with my family about not only my personal wishes, but their personal wishes, that this really makes a difference for folks, and we just need to understand what their preferences are. We're not here to cast judgment or to say this one is better than the other option. We are here to understand how they want their end-of-life treatment and in how they want to be honored. So we're not here to say you need to donate. No, don't donate. We just want people to document what makes sense for them and what is true to them. And the reason why I was sharing that personally having these conversations with my family, I have some individuals that are definitely pro organ and tissue donation, and I have others that do not want to donate their organs and tissue. And at least in my case, we have not tried to make someone change their mind about it. It's more, how do you want to be honored? And let's make sure that we understand what you want, even if it's not what we would like to see. Okay, so just know that no right or wrong. This is what makes sense to you based on your preferences, based on your beliefs. So Section 7 is your signature. So remember that if you're going to get this document notarized, pause, do not sign it. You will need to sign it in front of the notary. If you're not going to get this document notarized, then go ahead and sign your document. You say when you completed this document. So the 20th day of February 2020. So whatever the date is, you make sure you complete it in this format. And here Jane Doe has signed. Once again, if you're going to get your document notarized, hold off on this part until you're in front of the notary. So Section 8, this is where your witnesses have to sign. Whether you get it notarized or not, you're going to need those two witnesses. When you get it notarized, you also need two witnesses. So if you get the document notarized, you're taking care of two birds with one stone. So Section 8, you're going to say who you are. So this is where Jane Doe puts her name. She is the declarant, so this is where her name goes. And here we have the areas for witness 1 and witness 2. So Sam Smith has signed where it indicates signature of witness, and then Sam's name needs to be printed, and then Sam needs to provide an address, and this needs to be a full address with the unit number, the street, the city, state, and zip code. If there's any apartment numbers or anything like that, those need to also be included. The notary will need to require proof of ID. So both Jane, Sam Smith, and Sam Cook will need to give proof of ID. And here we have witness 2, which is Sam Cook, Sam Cook's signature. Then we have Sam's printed name, and we have Sam's full address. And the last item, if you're getting your your document notarized, is the notary seal. Your notary will complete this part. You do not have to complete this part. That is part of their responsibility. So they'll put their notary seal, and they will indicate what state, and that'll be Colorado, the county where you're getting this done. In this case, we're using Denver because the society is in Denver County. The notary is going to say who the declarant is. In this case is Jane Doe, who's completing her document. The two witnesses are Sam Smith and Sam Cook, and both Jane and both Sams voluntarily completed this document, witnessed the document on February 20th, 2021. The notary will sign the document, and they will indicate when their commission expires. So I often get a question about what happens if the commission expires on the notary seal placed on my document. Does my document become null and void at that time? And the answer is no. So the way that notary commissions work, they're set for a certain number of years. And when you're completing the notarization process, you need to indicate when it expires, so it's known that this document was completed during a valid commission. So unless you have to update your document and need to complete a new document, do not worry if that commission expires. What you need to look at is just make sure that at the time that your document was notarized, that this commission was valid and it was not expired. Either than that, it doesn't impact your document any other way as far as the notary commission expiring or anything like that. It just has to be completed when it's valid and it hasn't expired. So now that we have our document completed, we want to make sure that it's stored properly and the right people have copies. If you have heard me speak or have joined me in any of the other webinars in this webinar series, I say this, time and time again. You need to make sure that the right people have copies, and that you do not put this document in some magical box that no one knows that it exists and that no one could get to, right? So you always keep the original form. Make yourself a folder that has all of your advanced directives. You keep the originals and you give copies to your agent. This is the person that is listed on your medical durable power of attorney. You give copies to your alternates. If you have alternates in your medical durable power of attorney, those are the folks that need a copy too. And give a copy to your doctor. And that will make sure that individuals have copies. In addition to that, I always recommend to have a copy of your medical durable power of attorney and your living will, either behind your main door, your main entrance, on your refrigerator, or next to your bed. When 911 is called for any type of medical emergency and the medical team comes to your home, those are the 3 areas that they're going to look for this type of documentation. Right now, the state is working on a system that will work statewide where we are able to upload these documents. They're in the works. So right now, we just need to make sure that we have paper copies with us. If you're going to travel, just like you carry your ID, you should also carry your advance directive. So if you do have an emergency, a medical emergency, there's a contact person, and they know who they need to contact. So once again, keep the originals in a safe place. Let your agent and your alternates know where the original is in case that they need to provide copies of the original or show the original, and give copies for them to have. Your agent, your alternates, and your doctor, depending on who you have as insurance. If they use electronic files, they are able to upload it to their electronic file, and they're able to pull it up. Not every insurance group has that, but make sure that you do have the copies just in case, because this document will be used in case of an emergency. Sometimes you don't have a choice in what hospital you go. So even if you've given your hospital of choice and your doctor copies, they might not have it if you have a medical crisis and they send you to another hospital that was not your hospital of choice. So just make sure that at the time of need, the copies are available so they know who your agent is, your alternates, and how to get a hold of those individuals, and what your medical preferences are for end of life. Also, I want to emphasize that your advance directives, see them as living documents. You are doing yourself a disservice if you complete them once, put them away, lock them away. Nobody knows that they exist, and you never review them. Every decade of our life, we are changing, our priorities are changing, our health is changing, and we want to make sure that as those things happen, that we are also reviewing our documents. So I highly recommend that you review your documents, your advance directives, at least once a year. It doesn't mean that you have to make any changes. We just want to make sure that you review them so you know if you need to make any changes. Other times when to review your advance directives as needed is when there's a change in any of your conditions or condition. If there's a new diagnosis, if you get married or divorced, specifically for your medical durable power of attorney, when you have your spouse listed as your agent and you get divorced, that document becomes voided with that divorce decree. So at that point, you would need to complete a new medical durable power of attorney form. And at any time, if you change your mind about the medical treatment that you want to receive, or you want to change who your agent or your alternates are, at that point, you complete a new document. So make sure that it is a live document, and we're looking at it frequently and making sure that it still meets our needs and it makes sense for what we want. Also, advanced care planning as a whole doesn't start and stop with medical. It's one of the areas. These webinars are designed for you to look at advanced care planning in a very comprehensive way, where we're looking at these different spheres that make part of our life, and how do we plan in those spheres to make sure we're as protected as possible. So the medical durable power of attorney and living will, that is only one piece that is part of the medical advance directives. There's financial advance directives, and then there's a lot of legal things to consider when our situation changes at end of life, past end of life, and now after death. So note that this is only one piece of the puzzle, and I invite you to to join me in future webinars to make sure that we also cover other medical pieces, the financial sphere, and the legal sphere. So now that we're at the end here, once again, note that I will make this recording available to you. I will make the slides available to you. We have 10 more minutes, so let me get to the questions to make sure that your questions are answered before we end this session today. As part of the slides that I will make available to you, you will have this resource slide where you will be able to click on any of these links and you will be able to have access to the Advanced Directive Toolkit by the Society, the form that we went through today, other medical advanced directives, as well as access to other webinars on advanced care planning. So let's see, we have a question. Are the living will and durable power of attorney, and this is specifically medical durable power of attorney, are they valid if you die out of state? So the purpose of the medical durable power of attorney and the living will is when you're alive. So the medical durable power of attorney and the living will, as soon as we pass away, they are no longer valid. So this is why I say that advanced care planning is a continuum, and there's things that we have to do and prepare for after we pass away. So to clarify, what I think you're answering is, if you have a medical emergency outside of the state of Colorado, will your living will and your durable power of attorney be valid in that state? Yes, and in order for you not to have any potential barriers, I highly recommend that you please get both documents notarized. Do you provide a method of contact for Section 4? Let's go back to Section 4. Just to make sure that I answer your question correctly. So consultation with others. So the consultation with others, this form does not have a specific line how to contact this individual. This is where you are able to be in communication with your agent, especially if you have a large family, to have a list of those individuals that you want to be consulted with and notify, to make sure that your agent has all of their names and the way to get a hold of them. And nothing prevents you from putting their contact information here. Okay. So let's, we have another question, and it indicates important to make sure witnesses are qualified to witness. So this is an important key. Make sure that your witnesses are not the individuals that are your agent or alternates in your medical durable power of attorney. They have to be anyone else but your agent and your alternates. It could be your neighbor, it could be someone that you've known for a really long time, or someone that the notary provides if you're going to get your document notarized. So your agent and your alternates cannot witness this document, because then there's a conflict of interest, as they are the ones that would be making the medical decisions in the event that these documents go into effect. Another question is, how do you donate your entire body to science? So if you want to do whole body donation to science, I would recommend for you to look at the anatomical board with CU. They have a whole process to create a contract with them. They tell you which bodies, basically what is the requirement for you to donate your entire body to science, and how it will be used. The other thing to know when you're donating your body to science is whatever body remains are cremated and provided to the family. It could take a couple or few years to receive those remains. So I would highly recommend that you have that conversation with your loved ones so they know that they're not going to get the remains immediately, that they might get it 2-3 years after your passing. So once again, anatomical board with CU Health. So another question was presentation on 210, a repeat of presentation 122. So I think to clarify the question is we had 2 webinars on how to complete your medical durable power of attorney, and those 2 webinars were live and they did cover the same topic. So in the past, it's been requested that we please have those live so individuals are able to ask their questions during the webinar. So yes, the webinar on February 10th and January 22nd were the same topic, how to complete your medical durable power of attorney. And they were in this same format where we were talking about the medical durable power of attorney and how to complete that form. Those recordings are available. Our YouTube channel has those recordings available. So if you ever want to revisit any of our webinars, they are available there. And like I said, I will make this recording and the form available for you after the session. Can we cross out nutrition and only request hydration? So with something like that, I would recommend for you to talk to your doctor so they could provide you with more information of what that would look like. And I would recommend that you do not alter the form, because then you could get into questions about whether your document is valid or not. So we would want to use other directions to be that specific, to ensure that you understand if that is a possibility to do, what that would look like, and that you've consulted with your medical professional to make sure that you understand what that looks like. So let's move on to the to another question. I have completed paperwork directing my complete body for research. Do I list the name of the company in my list of people to be informed, or my imminent demise? So the way that I would tell you to handle that is you need to decide who's going to help you with everything once you pass away, right? Because your medical durable power of attorney, that person is only authorized to help you with medical treatment while you're alive. So this is why I say our advanced care planning also needs to take care of what happens after we pass away. So there's different ways that you could do this. You could complete a medical a last will and testament where you authorize someone to help you with everything that takes place after you pass away. And as part of your last will and testament, you could include what you want to happen to your body. I recommend that all of those documents, you have them in a folder where that person that you have talked to, they have agreed to assist with this process. They know that you've already put this in place, who they need to contact, what's the contact information, if there's any policy or any information that they have to give, where to find this information and how to go about it. So there's nowhere in the living will to put this, because the living will is just for medical care for your last days of life. What you're talking about specifically is what you want to happen after your death, and that needs to be documented in a last will and testament. Have the conversation with, and it could be the same individual who was your agent under your medical durable power of attorney. There's no problem, but you just need to make sure that that is planned accordingly, so we know what's happening while you're alive, during end of life, and then after your passing. So I have gone 1 minute over our allotted time. I do apologize for that. So let me just scan the chat to make sure that I've answered questions. So bear with me for a second. So what is the difference between the last will and testament and the living will? So the living will is specifically for medical treatment during your last days, and the last will and testament is your plan to what's going to happen to you, your property, and everything else after your passing. So living will, medical treatment; last will and testament, what happens after we die with our belongings and our property. When in your home, where in your home should you keep copies for your medical emergency EMT? Where do we get copies of this form? So as I mentioned before, I will make this form available to you via email after the session is done. And 3 areas. You could either put it on your refrigerator, on the back of your main entrance to your home, or next to your bed. That's where EMTs will look for your advance directives. And those are all the questions. So once again, thank you so much for joining me. I hope that you're able to join me for future webinars. We will go more in depth into advanced directives and doctor's orders and how those change, and how, based on your situation, how which ones you have might change. And we'll go through some different scenarios to give you a better idea as we continue to make sure that you understand the full scope of advanced directives and looking at them as tools and what tools you need to have to better serve you and protect you. So once again, thank you so much. I will make all the information available to you, and I hope you're able to join me next week. Have a wonderful day.